that point, because from the time you start using that unlicensed software until it's discovered by the software licensor, you're subject for potentially all of the profit that you made using that software. You might have to disgorge all of that profit to the licensor. So no way is it worth it. So check your own computer, check your employees' computers, and make sure that they're not using pirated software or unlicensed software. That's a really big deal. Employee relations, everybody knows that there's sexual harassment and all kinds of protections in OSHA. There are other protections that employees have. There's wage protection. The best thing to protect yourself, besides knowing the law on employment law, state and federal, is to have an employee handbook that lays out what you expect from an employee, what rights you have in terms of termination, in terms of whether or not you have to give them raises and how often, whether or not they have to have reviews. It's really a good thing to have that in writing, and once you have it in writing, keep it in a format that you can modify it easily, and audit yourself from time to time. Make sure that your employee handbook is really saying what it is that you really do. A lot of times in small businesses, you'll make changes and everybody smiles and nods, and then again the disgruntled employee will come back and go, but look, that's not what it says here. And you're stuck with what it says in that employee handbook. So once having written it, make sure that it's up to date.
And Patricia and I were talking a little earlier this afternoon about a case that came into play a few years ago, that in those employee handbooks, you've got to make sure that it expressly says that you as the employer can change it from time to time without notice to the employee and without their consent. Otherwise, there's an issue as to whether that becomes part of the employment contract and whether you would need the consent of the employees to modify the handbook.
That's right. Under Arizona law, we're an at-will state, so everybody thinks as an employer that you can do whatever you want. But you can't do something that affects the work that the employee has already put in. If you're going to change the deal, it has to be going forward. It can't be retroactive. Yeah, thank you. Buying and selling products. Make sure you know whether or not you're giving warranties, whether you're disclaiming any warranties. Make sure that everything is in writing, your purchase orders, your invoices, your statements. Make sure that your purchase orders and invoices and statements state clearly the terms, the time in which the money is due, what the interest penalties are, and you always want to have in writing that the prevailing party in the case of litigation, and we're not saying we're avoiding litigation, but in case there's litigation, the prevailing party is entitled to attorney's fees and costs. And the reason this is important is in Arizona, even though if there's a contract, you get your fees. If there's a default, you don't. And a lot of times when you're dealing with a client or a customer that's in financial trouble and you sue them to collect, they will just simply not answer because they know they owe the money, they know they have no defense, so they'll default. In that case, you don't get your fees unless it's in writing on the invoice or on the purchase order or on the statement. It has to be in writing that your fees, so it has to be part of the contract. Be reasonable about litigation. It's not about the principle, folks. It's not about the principle, it's just money. So when it gets to a point that it's going to go to trial, don't go to trial. Settle the case if you possibly can. Nobody wins at trial. Everybody says the lawyers win at trial. That's not even true. Nobody wins at trial. So put yourself in a position where you mediate early on. Try right from the beginning to negotiate the dispute. Mediation is an excellent way. There are private mediators. There are court-appointed mediators that will help people find that middle ground that they can walk away from and still operate the business afterwards. And that's what you really want. You want a business that's going to keep on going after this dispute is done. I guess that's it.
Yeah.
So you want me to do this one too?
Yeah,
Okay.
talk a little bit about
Organizational documents. Are all of you LLCs or any of you in corporations? Your corporation? Okay, so you know that if you have a corporation, the formality of documents is something that is a much higher level than an LLC. So in the case of a lawsuit, if you haven't been keeping your, if you haven't been holding your annual meetings and if you haven't been keeping minutes from the annual meetings, there's possibility of what's called piercing the corporate shield, and that's a very formal term for meaning that your protection from personal liability goes away. So make sure that you have articles of organization or incorporation, all your operating agreements are up to date, and that you have your annual meetings and minutes of the meetings. And the minutes of the meetings can be written afterwards as long as all of the shareholders sign, but they have to already be done before you get a lawsuit against you. So to make sure that's all in place. Any other organizational documents we need to talk about?
No, just that you have, particularly for corporations, all of those initial organizational documents, the articles of incorporation, bylaws, meeting minutes. All too often those things just get bypassed or they're either never put in place or not updated.
Yeah. Okay, obviously you want to keep your insurance current on everything and make sure that it's sufficient to cover your actual potential losses. Make sure it isn't something that you figured out 10 years ago and all of a sudden you have a loss and you're not covered. Again, employee issues, make sure that all of your contracts are up to date. If you have any written employment agreements, which some people do, sometimes they're annual, and a lot of times what will happen is the year will go up, will pass by, the employment agreement doesn't get rewritten for the following year, and so under Arizona law, the existing employment agreement continues on in force, and you may want to change the terms on the new employment agreement. So make sure that if there have ever been employment agreements with any of your key employees, that they are current and that they actually say what you want them to say.
And that's true for a lot of different kinds of contracts too. Many contracts have what are called evergreen provisions, which essentially say after the term of the existing agreement expires, it automatically renews for successive periods of time unless a party terminates within so many days prior to the end of the term. I've run into a number of circumstances where clients thought they were no longer bound by the existing contract because the term was up, not realizing that it automatically renewed for another 1 year, 3 year, 5 year term. And you've got to be very careful to watch those automatic evergreen renewal provisions to make sure you don't get stuck in a contract you no longer want to be a part of. And those are strictly enforced in Arizona, so you do have to be very careful about those.
Right, and I guess that goes to the employee benefits too. Basically, all of these are things that you should put on a checklist and, in your copious amounts of free time, go through and check and make sure that they are current as of September 29th, 2011, and sort of try to make yourself do that again on at least a semi-annual basis, if not quarterly. You want to check into all of these things. Contracts includes not just with your employees, it includes leases, it includes any equipment purchases that you have. Obviously, your customers you might have contracts with. If you have a printed form that has terms and conditions on the back, a lot of people use. Take the time to read through that so you know what it says and know that that's actually what you're doing. And if it's not what you're doing and if it's not what you want to say, for God's sake, don't keep using it, because those terms and conditions on the back are binding. They bind you and they also bind your customer. And by the way, if you ever fax one of those things to someone, be sure you fax the back. I've actually seen situations where somebody has very carefully done all the terms and conditions and they're on the back, but when they fax the invoice to the customer, they only fax the front. And so the other part isn't part of the contract, and the customer isn't bound by what it says on the back. So it's silly stuff, but it'll bite you. Governmental compliance. Okay, I'm sure you've all heard that you're not protected by ignorance of the law, and that's absolutely true. You could be doing an environmental hazard. You could be doing. You could have a licensing issue. You could again have an employee harassment issue. All of these things go to governmental compliance, and you are responsible for knowing the laws that affect your business. This stuff it's all over the internet. You can do all kinds of research yourself and find out a lot of stuff. And obviously, Ron and I are here to help you with that as well. But you can't say I didn't know. That's not a legal defense.
Well, what I want to move into talking a little bit now about is this contingency planning concept. How to deal with business continuity if something happens to the owner of the business. And then we're going to touch a little bit on a number of different techniques that can be used to transition the business, whether it's to a third party, to a family member, to a key employee, or other insider of the business. One of the things, a good buy-sell agreement, and by buy-sell agreement, what I'm talking about is not a sale of the business, but essentially a shareholders agreement, or in an LLC, if I've got multiple owners in a limited liability company. These provisions are typically found in the operating agreement for the LLC. It's the agreement among the owners, among the co-owners of the business, as to what is going to happen if certain circumstances occur. And what a good buy-sell agreement allows for is the retention of ownership and control of the business. For example, if a co-owner departs, it allows for the ability, perhaps, to force a non-contributing owner to depart from the business. You'll see this oftentimes where co-owners will go into business together, and it ends up where one or more of the co-owners just doesn't contribute as much as the parties thought they were going to as the business goes on. But being in business together with a co-owner, in some ways, is as good or bad as being married. In a marriage, there's a way out. You could get divorced. And when you're in business together with somebody, there is no way out unless you provide for it in a good operating agreement or buy-sell agreement. Good buy-sell agreement can provide for consistency between lifetime and death objectives, right? Lifetime objectives allowing a good transition of the business and keeping the value of the business upon, for example, the incapacity of an owner, or good death objectives. Upon my death, if I want to ensure that the value of what I have worked so hard to achieve during my lifetime, my family might benefit or enjoy the benefits of. It can ensure the survival of the business for the benefit of family members if something happens to the owner. And again, ensures the value of the business is ultimately going to be received by the family in the event of certain contingencies. So a good buy-sell agreement or operating agreement in an LLC is oftentimes going to touch on these kinds of issues, triggering either a buyout obligation among co-owners or a buyout option among co-owners in the event of disability, incapacity, retirement, the death of an owner, the divorce of an owner, termination of employment, the bankruptcy of an owner, or as a way to resolve business disputes. And in a minute, Patricia's going to talk a little bit more about that in terms of good buy-sell planning. But one of the critical things I think that a good buy-sell agreement has to have in it is to address all of these different kinds of circumstances. Oftentimes I've taken a look at a buy-sell agreement that may talk about what happens upon the death of an owner, but never gets to the level of talking about disability or divorce or if an owner ends up in bankruptcy, right, or is insolvent. All of these issues have got to be properly addressed, or as a co-owner, let's say you're in business with somebody else and that somebody else now gets divorced, right, or ends up with a bankruptcy or other creditor problem. Well, you could easily end up in business with now somebody else, and somebody you don't want to be in business with because your agreement did not address that specific contingency. There are basically two types of buy-sell agreements. One is a redemption scenario, and the other is a cross-purchase scenario. In a redemption scenario, this is where the shareholders or members of an LLC enter into an agreement among themselves and with the company that says the company itself will buy out the ownership if something happens to the owner. Whether that something is incapacity or disability, whether it's death, divorce, retirement, all of the various kinds of issues that ought to be addressed by a good buy-sell agreement. And oftentimes, the circumstances under which the company is to buy that interest might be very different depending on what the circumstance is. For example, if I'm a co-owner in a small, closely held business, I might want to ensure that upon my death, the company has the obligation to buy my interest out, so that my wife, my kids, they're going to be able to enjoy the benefit of the value of my ownership in that business. On the other hand, if I became incapacitated or disabled, particularly if I was a passive owner in the business, that my day-to-day activity in the business was very small or very little, I might not necessarily want the company to have the obligation to buy me out. Now, if I'm the company or another co-owner, maybe I would want the ability to buy out a disabled co-owner. But all of these issues are things that are subject to negotiation and have to be determined at the outset so that the issue is resolved before the problem actually arises. In a cross-purchase scenario, this is where the other co-owners would have the ability to purchase the interest upon one of these triggering events happening. Again, whether that triggering event is death, disability, divorce. In either scenario, whether it's a cross-purchase arrangement or a redemption arrangement, and oftentimes a good buy-sell agreement will be a hybrid of those things. In other words, it'll provide for the buyout of an interest. Maybe the other owners will have the first option or obligation to buy that interest out. And if they do not purchase it, the company would have the second election or option. So it can be done by a hybrid as well. And there are just very different tax consequences that arise depending on whether it's a redemption or a cross-purchase arrangement. But a good buy-sell agreement is one mechanism to at least ensure the viability of the business if something happens to one of the owners. And as a co-owner in that business, it gives you the confidence of knowing that if something does happen to one of your co-owners, you're going to have control over who you stay in business with. So I've talked about how the different types of agreements work, the cross-purchase or redemption agreement. The other things that have to be covered in a good buy-sale agreement is, if something happens and a triggering event occurs, whether that's death, incapacity, divorce, bankruptcy, the purchase price, how that interest that I now own in the business is going to be determined and valued. It's critically important that the agreement itself dictate how that price is going to be determined. Now, oftentimes it'll just say, it'll be determined by appraisal, or some other objective mechanism for determining what the value is. I'm in a circumstance right now where the husband passed away owning a majority interest in a limited liability company with two other co-owners. Unfortunately, in that agreement, it was stipulated that the purchase price upon this triggering event of death would be just the book value of the business, assets as against liabilities. And in this case, the book value of that ownership is substantially, significantly less than if the fair market value of the business would otherwise have been used. We had an appraisal come in that was close to 4 or 5 times greater than the book value of the business. So giving good, objective, hard thought as to how that purchase price will be determined going into the agreement is critically important, so that if or when one of these triggering events occur, you don't have a family member get stuck on the back end not getting the true value of the business out of it. The advantages of having a good buy-sell agreement? Well, it provides protection to the company and certainly to the other shareholders and other co-owners. And again, it's principally this idea of ensuring that as a co-owner, I can stay in control of who I'm in business with by having the right to buy out the interest of a deceased or disabled owner. Some of the disadvantages of a buy-sell agreement. Well, it's only part of the overall package because it does not accomplish, good overall estate planning. I mean, it may provide, for example, liquidity and value to my family if I'm the co-owner that dies, but that's all it does. It doesn't address what's going to happen to that money and that value once it comes into the family. Good, effective estate planning still needs to happen as part of this buy, sale, and contingency planning to make sure that value ultimately gets to the right people in a way that's not going to be lost to taxes. And really, no wealth transfers received. In other words, in a few minutes, we're going to talk about various ways to transfer the family business in particular to key employees or to other family members. All a buy-sell agreement does is ensure that I get, and my family gets, the value of that business into my estate. It really does not allow me to transfer that value now to other family members in a tax-advantaged way. And that's what we'll talk about in a minute, that transfer to other family members in a tax-advantaged way. So,
Okay, well, again, litigation avoidance. I keep talking myself out of work, because what I do is litigation. Purchase price determination, we talked about